Hello friends, I welcome you back to my second lecture series on Unit 6 Intellectual Property Rights. This unit has been introduced for MBA third semester, MBA second semester as a compulsory subject in uh, uh, in research methodology and intellectual property rights. Myself, Dr. Basavaraj S. Kurchimat, your teacher for the subject research methodology and IPR. I'm going to discuss today the origin and development of intellectual property rights. In the previous lecture series, we have already seen, in the first lecture series, we have already seen what is IPR and what are the characteristics of intellectual property rights. Today, let us understand the historical events relating to intellectual property right introduction. Friends, the journey of this intellectual property right has taken right from the ancient period. The history of this IPR is not less than 2,500 years. Intellectual property rights protect the creations of the human mind from inventions and literary works to symbolize and designs. This fundamental concept has evolved dramatically over 2,500 years, shaped by cultural values, legal frameworks, and technological innovations. 2,500 years is not a small term. Right from that, before 600 BC itself, there are certain instances which have upheld the intellectual property rights of the artisans, artist people, and creations of the what do you call as designs for the ship and all that. Let us discuss today how this has evolved in the historical way. Ancient beginnings, if you see, the first seeds of the intellectual property has come out from the kitchen, which the Siberian innovations in 600 BC, that is before the Christ, before the birth of the Christ, 600 years before the Christ birth. That is a very, very olden time, which traces around 2,500 years back. In the Greek colony of Sybaris, that renowned for its luxury and culinary arts, officials granted exclusive rights to chefs who created exceptional dishes. For 1 year, no other cook could replicate their culinary innovations, making perhaps the earliest documented for its intellectual property protection. It means that during 600 years of a Christ birth itself, in the Greek colony, Greek had a Siberian colony there, where the Greek has introduced compulsion to the chefs. Chefs are the people who prepare the foods for the kings of the Greek colony, kings of the Greek colony, where anybody who prepares the delicious food, it was told the same person again and again to prepare it. No third person can copy it or do accordingly or replace that particular person of doing the same menu again. So this was giving a particular credit to the innovated chefs to serve the king for a 1 year next for that particular delicious food. This is what we can trace, assigning the rights to the person who has created to maintain it for at least 1 year during that particular. This was giving a credit and recognition for the chefs for innovating a new cooking styles. This revolutionary concept recognized that the mental creations deserved economic protection, establishing a precedent that would evolve over millennia. It means that this has given a thought for intellectual property protections during 600 BC itself. If you come to the next aspect called Roman legal foundations, Roman jurisdictions made a cultural conceptual breakthrough by distinguishing between what we call as physical object and the intellectual content. It contained separating the scroll from the story, the canvas from the art. It means that the kings of the Roman time have made it mandatory to the artist to not to copy by others when they invent a new canvas. The picture says this is the first canvas developed by one of the artists there, and it was protected with the seal of the king that nobody can copy this or replicate this again, doing the same kind of a thing. So this was considered as a Roman initiative in creating the copyright for the artists and all that. This has given an economic what do you call as safety for the people, for the artist to sell it to the kings and to other people and create that particular thing and maintain it for the long period of time. Medieval and Renaissance development, if you can trace, Renaissance has come in the 6th century, where new thoughts, new innovations, new kind of things started emerging. This period is called as a medieval Renaissance. Medieval is the middle time of the Renaissance. During that 6th century onwards, you might have heard that the Islamic countries, Islamic what culture started emerging. During the 6th century, see, King Diarmait of Ireland makes makes famous ruling on the copying of the Battle of the Book. When the Battle of the Book was being copied by some people, the king Diarmait made an instruction not to copy it because he gives a verdict with the sentence: to every cow belongs its calf, to every book its copy. It's the copy of the owner. When the calf belongs to the cow is the main author or main creator of the calf, then the responsibility of a calf lies with the cow, like a book is to the writer. Hence, establishing clearly the copyright principle during that time and upheld the concept of copywriting. Again, in 1421, we can understand the Filippo Brunelleschi receives a 3 years exclusive right to his innovative boat designed in the Florence. Florence was the city where an innovator, that is Filippo Brunelleschi, created a novel kind of a what do you call as boat, designed a particular boat. The design of the boat and its picture drawn is there in the film itself, that you can see how the design was made by that person. And this design, when it is made, it should be created by the same person only. No third party can copy it. So this has given a 3 years exclusive right to the innovator of the boat design in Florence. That is city of Florence, often cited as the first recorded patent in the history. That you can understand this. Another important is Venetian patent in Venice city, which is in the Italy now. The Venice city has passed the statute in 1474. Till 1474 to 1729, it was a separate country ruling on its own. But in 1883 and all that, it has come under the France, Italy by the Napoleon Bonaparte. He vanished the sovereignty of the Venice and it was merged with the Italy later on, with the France and Italy later on. So during 1474, when Venice city was independent country, through its parliament, that is called the patent statute, was created. It is considered the world's first confident what is the codified patent. They started codifying a patent. When the patent was codified and numbered, it cannot be copied by anybody, requiring innovations to be novel and useful while granting exclusive rights for 10 years. It means as when the patent was copied, that is coded, it cannot be copied by anybody for the next 10 years. It was protecting the rights of the owner, creators, to protect it from that. So a code was given. Once the code was printed on that particular design or copyrights or on the book, nobody can copy it. That is how the first coding system in the world started, with the Venetian patent statute. It is called as Venetian patent statute by the Venice city of the Italy country now in 1474. Then late in 15th century of the Renaissance, that is humanists champion individual creativity and artistic rights, with Albrecht Dürer and others fighting against unauthorized copying of their works. In the Renaissance, the what you call as Albert Dürer, who was the person in the Italy, who was a writer and a painter, and he followed his father. His father, what is called as William, was the what you call as a goldsmith. Under his what you call as guidance, his son Albert, that is Albrecht Dürer, developed an art of painting and also a writing of a books and all that. He was a very good artist. When his arts were copied by many people during that time, he raised and made a fight against the people who are copying and approached the king to pass an act to protect it. So, and he could succeed by developing a copyright works with in the year 15th century itself. So, this is what the Renaissance period marked a pivotal shift towards recognizing the value of innovation and creative expressions, laying foundations for to frame the intellectual property systems in the country. So it has started Renaissance in the 6th century. During that time, copyrights and patents got very much what you call as accepted by the kings, and rulers started implementing it in their countries. You can even identify the modern IP laws in England. You could find out some of the laws have been passed in the England. That is Statute of Monopolies in 1623. The crown's powers were diminished in giving the monopolies. That is, the monopolies which the crown was having was objected, and the crown's monopolies were authorized only for the 14 years. That the monopoly can be established by the people who innovate any kinds of new things. That next 14 years they are the only enjoyers of this. This landmark legislation curtailed the crown's ability to grant arbitrary monopolies while establishing a 14 years exclusive right for true and first inventors. It became the cornerstone of Anglo-American Patent Act. That is what in the year 1623. And this act has also entered with the colonies of the England whenever they go. Even it has entered the country like India also later on. Statute of NA in the 1710, one more act was passed by the England, an act for the encouragement of learning. This pioneering copyright law transferred rights from publisher to authors. That is, the publisher to authors, establishing a 14 years protection period with the possibility of renewal for another 14 years. It means that the publishers who used to publish the books, once it is written by the authors, the publishers were exclusively using their rights to print multiple copies. But later on, it is identified the publishers don't have the right to print the books unless and until the author gives the consent for it. Hence, authors were given the power to protect the copyright that is misused by the publishers. So 14 years time was given to the authors to withhold their what you call as right of patents and copyrights, and can direct the publishers not to publish without their consent. This statute was passed in the year 1710. Another one is intellectual property right word was coined in the year 1969, the first appearing in the legal decisions. This terminology reflected the growing understanding that ideas and expressions could be owned like a physical property, a revolutionary concept that continues to shape our legal system. In the year 1969, England only has given the specific word to this intellectual property word. Intellectual means intangible ideas or the knowledgeable works that is created is called as intellectual property. Like a tangible property, it is also being protected by the England. You can identify even in United States of America also a lot of developments have been made in the field of intellectual property rights. The first intellectual property rights in America started in the year 1787 with a article on the intellectual property right. That is Section 1, Clause 8 of the US Constitution, 8th US Constitution, writes the word in its constitution. That is, the photo has been given here, extraction of that. The oldest constitution, what it says is to promote the progress of the science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. This word has been given. It means that a law has been passed in the 1787 by the Constitution of America under the Section 1 and Article 1 and Section 8 of the article empowers the artists and the authors and the inventors to protect their rights. And you can even see the American IP development that has happened in 19 based on this clause in 1790. The US Patent Act was signed by the George Washington, the president of the US at that time in 1790. Then in 1800 in the year 1800, patchwork of a state laws created a inconsistency in IP protection. There was no perfect consistency. In 1870, first unified federal trademark law enacted. In 1870, the new enacted was made, and it was made serious to protect the serious actions were made to protect the intellectual property of the authors and the scientists and the innovators. In 1982, the Court of Appeals for the Federal Circuit established to handle patent cases. It means that in 1982, Act was made a separate body to control the federal, the government was made to handle the patent related cases. That earlier it was clubbed under one single presidential act, but later on a separate department was made as a federal law to act in the to control the patent activities in 1982. The American system notably balanced monopoly rights with the public benefits. The main intention was to protect the monopoly powers of any author on all that for a particular period of time, and it balanced the need for the public utility and also the author's rights to earn money on that. The economic benefit for both the public and the innovators were balanced through this American acts. You might have seen immediately after this, the after the Renaissance, the globalization came. After the Second World War, you can identify that a lot of international trades were initiated by the developed countries like France, Greece, by France, England, America, and Russia. They started merging together and started doing so. Intellectual property right was internationalized, that the property rights were established at the world level. The Paris Convention in the 1883, the first major international treaty protecting industrial property across borders, established the principle of national treatment, requiring countries to give foreign investors the same rights as domestic ones. When foreign countries are investing money in the other country and bringing the technology for the development in the other country, the countries where the foreign investment and the technology has come should also implement the rules and regulations what is there in the home country of the investors and the people bringing the technology. So the technology protection was made in the developing countries where the investment is made. It was made mandatory in the international level by the Paris Convention, and all the members of the countries, this Paris Convention accepted to protect the rights of the foreign countries which are investing and bringing the technology within the country. Then Berne Convention in 1886 created international copyright protection for literary and artistic works, established the revolutionary concept. Earlier in 1983, only the intellectual property of the technology brought inside was protected, but in 1986, even the copyrights, what you call as the publications of the books and everything was told to protect in the international level. It has established the revolutionary concept that copyright exists upon creating without registration requirement, no registration requirement. If any foreign country comes in and publishes the books and all that, the other country should protect the rights. They cannot copy the foreign country products, foreign country books and all that. That was made restricted, not required to register. Anybody who raises an issue without the registration also that the book has been copied or some author works or artistic works were copied out, the strict action was taken at the international level. Madrid system in 1991, you know, that established international trademark registration. Madrid was a particular discussion made in the 1991, and it has come out with the concept that trademark registration framework allowing protecting cross multiple countries through a single application. When the multinational organizations entering into different countries, their products were copyrighted and trademark was given to each product so that easily the product of the MNC company can be identified in various countries. That is why many foreign countries which are coming in India were protected by that particular trademark, and it was not copied by the local people at all in the same name, in the same style. That was prohibited in 1891. Then in 1967, the WIPO was passed, that is a World Intellectual Property Organization came into existence, became a specialized United Nations agency administering intellectual property, that is treaties, and promoting harmonization of intellectual property rights globally. So that WIPO was established and all the members of the country were restricted by this WIPO organization. WIPO was an independent organization created by the representations of the countries of the international treaty organizations. And this WIPO was managing all the country intellectual property rights that is protected in the subsequent neighboring countries where they enter into with investments and technologies. That was protected. That is what WIPO came into. In 1991, when India got what you call as globalization treaties and all that, one of the important clause which was mentioned in the globalization policy was protecting the intellectual property rights of the foreign countries. That was when this treaty was made, India also has accepted to protect the international level intellectual property rights in our countries. So these international frameworks transformed intellectual property from national system into a global work. They were at the national level at different countries. In US it was different, in UK it was different, and in Germany and Greece it was different. But when it came to common international level, when international trade and business started, the common platform was created and WIPO started controlling such kind of deviations from the countries, and international level of protection has came into existence. Okay, friends, with this discussion, I end this lecture series that is regarding the origin of the intellectual property rights in the countries and how it has taken shape from local government to the international level, how it has entered. So with this brief discussion, I'll end this lecture series. In the next subsequent lecture series, let us see the different aspects of the intellectual property rights. Thank you, friends. Thanks for watching the video. Hope this video may be helpful to you for preparing for exams. Thank you. Thank you.